If the court pleases, my name is Jonathan Preston and I appear on behalf of the prosecution. Your Honour, the defendant, Mr. Joe Andrews, is brought before you today charged of recklessly causing injury under Section 18 of the Crimes Act. This offence carries a penalty of Level 6 imprisonment, a maximum of 5 years. Yet considering this indictable offence as being tried summarily, the maximum total imprisonment available to Your Honour is 2 years. Gratuitous alcohol-fuelled acts of violence are a scourge on Melbourne's otherwise bustling and inclusive nightlife scene. To reflect the seriousness of the defendant's conduct, the prosecution proposes that Your Honour's sentence must reflect the following sentencing principles, as provided by Section 5 of the Sentencing Act. Firstly, the sentence must punish the defendant justly, in a manner proportionate to his wrongful actions. The nature of the defendant's conduct is of particular dangerousness and seriousness. In itself, the mechanism of glassing is of a highly dangerous nature, with the foreseeability of injury relevant in considering the gravity of this offence. Furthermore, the defendant continued attacking the victim after the glassing, ultimately resulting in a laceration requiring 5 stitches and a bruising of the torso. The victim has also described significant mental health impacts following the humiliation of the attack in his victim impact statement. This serious and injurious nature of this conduct requires the court to administer a stern but proportionate punishment. Secondly, the court must seek to deter the offender and other individuals from committing similar offences. The defendant has been convicted for similar prior offences of a similar nature, including resisting arrest and assaulting a police officer, but was not sentenced to imprisonment. With this offence only occurring after the victim identified himself as an off-duty police officer, a sustained pattern of animosity towards police officers demonstrated. Therefore, the sentence handed down should be harsh enough to specifically deter the defendant from committing another crime of this nature. Additionally, due to the dangerous nature of this crime, the sentence must also generally deter other individuals disposed to committing similar offences. Thirdly, the sentence must facilitate the rehabilitation of the offender. The defendant is a recovering alcoholic who had been sober 7 years prior to this offence. While the defence in counsel proposed this offence to have occurred in an extraordinary circumstance in the celebration of the passing of his father, this offence demonstrates the defendant's susceptibility to relapse. Thus, rehabilitation, particularly through alcohol counselling, is a pertinent sentencing consideration in this case. Finally, the sentence must communicate the court's expressed disapproval of the defendant's unacceptable conduct, manifesting the denunciation of such actions. Before offering the prosecution's proposed sentencing disposition, I wish to turn Your Honour's attention to relevant and comparable sentences. In the case of the Director of Public Prosecutions in Harrington, the County Court found the defendant guilty of recklessly causing injury following the glassing of an individual at a party. The defendant was sentenced to 9 months imprisonment as well as a 15-month community corrections order. And while the severity of the injury sustained by the victim is more severe in this case, there are essential commonalities requiring that this case guide Your Honour's sentence today. In the case of Constable Kendall, Informant and Pecker, the defendant pled guilty to the offences of recklessly causing serious injury and recklessly causing injury in an alcohol-fuelled act of violence similar to this one. The Magistrate Court sentenced the offender to 18 months detention. It is also relevant to note that the Honourable Magistrate Garnett asserts in his judgment that the court has a responsibility to impose custodial sentences on both young and older offenders who engage in mindless, callous and cowardly acts of violence as occurred in this case. All these factors considered, the prosecution proposes that Your Honour sentence the defendant to 4 months imprisonment and a 12-month community corrections order. The very nature of this offence demands that the custodial sentence be imposed. The dangerousness of this offence, the impact on the victim, and the prior convictions of the defendant indicate that without the sentence of imprisonment, the pertinent sentencing principles of general and specific deterrence, denunciation, and punishment cannot be upheld. However, it must also be brought to the court's attention that the defendant submitted an early guilty plea, exhibits remorse, and has good prospects of rehabilitation, qualifying the defendant to a sentencing discount. Therefore, the completion of the defendant's sentencing order largely in the community is fundamental to facilitating his rehabilitation, particularly through the proposed condition of alcohol counselling. The prosecution rests.